Hello, it's nice to be here at RSA to talk with you about the law of data security and specifically about how to determine whether the security controls that you or someone else may have applied to personal information were reasonable under the law. For the Sedona Conference, an influential think tank that provides technical guidance for the law, this exploration of reasonableness began nearly 3 years ago, when members of Working Group 11 observed that the law was all over the place on this point. Regulators and the courts and industry all had experience with reasonableness and that standard. Agencies commonly use reasonableness in their regulations and in their injunctions. Reasonableness was a staple in the industry, and the courts used it regularly as well. But there was real uncertainty about what the word reasonable means, and equal uncertainty about how to apply it. This was especially the case for the orders of administrative agencies, like the FTC. Two appellate decisions pointed this out. In Wyndham, the Circuit Court of Appeals was able to find an acceptable definition for reasonableness against which to test the applicable statute, the FTC Act, and the hotel's security controls. But the court had to look for it. In LabMD, the court was not able to find a definition for reasonable, and it rejected the FTC's order. The Sedona Conference decided it would try to develop a test for reasonableness, and it began by taking a look around to see what was already out there. One task force looked at the law, another looked at the regulators, and a third looked at industry. From the legal task force is David Cohen, a lawyer who defends clients and who practices with Orrick in New York City. David?
Thanks, Bill. I focus on defending companies that have suffered data breaches against the litigation and government enforcement actions that frequently ensue. And the issue of reasonable security comes up regularly in the cases that I defend. Class action plaintiffs and regulators always argue that our clients fell short of a reasonableness standard. So one of the key responsibilities that I have is to defend the reasonableness of our clients' security, among many other arguments that we raise in these cases. And I was part of the team that defended both Wyndham and LabMD in the cases that Bill mentioned just now, which has given me the opportunity to do a lot of thinking over the years about the issues involved in defining reasonableness.
Thank you very much. The regulatory task force looked at state and federal administrative agencies, and we're pleased that Jim Trilling, a lawyer with the Division of Privacy and Identity Protection at the Federal Trade Commission in Washington, D.C., is with us today. Jim?
Thanks, Bill, and hello, everyone. I am an attorney in the Federal Trade Commission's Division of Privacy and Identity Protection, which is the group within the FTC that investigates, often settles, and as David mentioned, sometimes litigates cases involving data security issues. Our interest in data security is on protecting consumers from harm that can occur due to a company's unreasonable or otherwise unlawful data security practices. Among other things, as Bill mentioned, we enforce Section 5 of the Federal Trade Commission Act, which prohibits deceptive or unfair acts or practices. Having unreasonable data security practices can be a deceptive practice. For example, it is deceptive for a company to promise consumers that it reasonably secures consumer data if the company does not, in fact, do so. Under the FTC Act, unfair acts or practices are those that cause or are likely to cause substantial consumer harm that is not reasonably avoidable and is not outweighed by countervailing benefits to consumers or competition. A company's failure to reasonably secure consumer data can be an unfair practice. We also enforce other laws that require businesses to reasonably secure particular types of data covered by those laws, and the Children's Online Privacy Protection Act is one example.
Jim, thank you. Part of the industry task force here is Chris Cronin, a partner with Haylock, who deals with reasonableness from the risk manager's perspective. Chris?
Hi, so I'm Chris Cronin. I'm a partner at Haylock, as Bill had said. I help companies determine whether or not they're using reasonable security controls through risk assessments and risk management, and sometimes work with those organizations when they have to have conversations with litigators or regulators. I've worked with Center for Internet Security and Phyllis, who you'll be meeting in a few moments, to develop the CIS's risk assessment method that helps people demonstrate that their security controls are reasonable. When I saw that I was defining reasonable in a way that was very similar to some of the work that people on this call were doing, it made good sense for us to work together on the Sedona conference to work on the paper that we're discussing today. It turns out we had a lot in common, which Bill will be talking about in a moment. But today I'll be playing the role of one of my clients who gets into a little trouble, and we'll see how it is I fare when I use the test.
Chris, thanks. And finally, meet Phyllis Lee, a Senior Director of CIS Controls. Phyllis will represent the Center for Internet Security and talk with you about the role it plays in cybersecurity risk management. Phyllis.
Hello, my name is Phyllis Lee. Like everyone's mentioned, I'm the Senior Director for the CIS Controls. If you're unfamiliar, the CIS Controls are a list of activities supported by safeguards or subcontrols that enterprises can implement across their networks in support of their cybersecurity program. The controls and their corresponding safeguards are chosen based on their ability to mitigate as well as detect the most common real-world threats or cyber attacks. That is to say, all our controls are backed by real-world data. However, even as security experts, we realize that not all organizations can or must implement every safeguard. That's why we provide a prioritization scheme called implementation groups. We believe that implementation group 1, or basic cyber hygiene, consists of safeguards that any and all enterprises should implement. Even still, we have to acknowledge that there may be safeguards in IG1 that an organization will not have to or be able to implement. It may also be the case where there are additional safeguards outside of IG1 that an organization must implement first due to their risk profile. This is why we provide the CIS risk assessment methodology that we worked on with Chris at Haylock, or CIS-RAM. CIS-RAM enables organizations to use a risk-based approach of the reasonableness test, which we'll be talking about today.
Very good. Thanks, Phyllis. We talked about the task force, and when they reported in, we were sure of a couple things. Reasonableness was, in fact, a common standard in data security for the industry, for statutes and regulations, and for the handling of legal claims. And determining reasonableness was, in fact, elusive. But we also discovered widespread familiarity with cost-benefit analysis. We reacquainted ourselves with an old piece of algebra, first stated by an influential judge named Learned Hand, and that's his real name. Judge Hand invented a cost-benefit formula for assessing reasonableness in a litigation context, and we found it helpful. But we decided Judge Hand's consideration of only the financial burden on the defendant, for us, we call that person the information steward, only the financial burden of adding the control, and on the other hand, the loss to the claimant from the absence of the control was missing something. What was missing, we decided, was what we called utility, namely any benefit that the unimproved conduct at risk created for others. A hospital's utility, for example, is healing patients. A school's utility is educating students. Having that utility and trying to increase it are why we take risks with information and systems to begin with. So the others that we thought were important included the public, other constituencies, and even the claimant. We added utility to the burden side of the cost-benefit analysis. At the end, the entire working group was comfortable proposing a test for reasonableness that reads as follows. An information steward's information security controls for personal information are not reasonable when implementation of one or more additional and or different controls would burden the information steward and others by less than the implementation of such controls would benefit the claimant and others. And viewed graphically, as you can see, the test looks like this. And if you're familiar with Judge Hand's decision, this is very similar to what he came up with. So to try to make all of this concrete, we're going next to a hypothetical breach case where the hacking was enabled by the failure of one control and arguably by the absence of another. Once we present it, our panel will talk about providing their different perspectives about how the test can be used to determine reasonableness. So here's the hypothetical. A social media health app collects health data and diaries from senior citizens. The data comes from wearable devices and from the web browsers on the user's computers. The app recommends changes in users' habits based on the health improvements it sees in the user database. Hackers appear to have acquired the user's credentials by phishing the users. The app did not use multi-factor authentication. The hackers have grabbed most of the health app's user data and have sold it on the dark web. And the fraudsters who bought the data are now using it, either to exploit what they already have or to target the health app's users for additional scams. So that's the hypothetical. And again, what we're going to do is bring to bear the expertise of all of our panelists to talk about it and talk about it in light of this test. So let's start with Phyllis. Just how important, Phyllis, is multi-factor authentication? Does CIS, for example, have any guidance for us on that?
Yeah, great. Thank you. Yeah, so most users are familiar with authenticating via username and password. MFA, or multi-factor authentication, adds an additional layer of protection and security against one of the most common attacks, which we just heard about, which is compromised credentials. In fact, Google reported recently that MFA prevents more than 96% of bulk phishing attempts, as well as more than 76% of targeted attacks. So due to this overwhelming data about the efficacy of MFA to defend against cyber attacks, we updated Controls version 8, being released this week, to support the latest research on MFA. So for example, our updated password policy guidance is going to say you can use an 8-character password as long as you're using MFA. The studies have shown that having long passwords really don't provide you any more randomness or entropy, and users fall into bad password practices. That's why MFA is better. Additionally, we're going to, we have safeguards that say MFA should be used for internet-facing applications, similar to what this health app would be, as well as given the pandemic and our current working conditions, MFA should be required for remote network access. Additionally, training is always important, and we've updated our guidance to include training the workforce on MFA. I would say we had an editorial panel of around 20 folks, security experts, and everyone touted the importance of MFA being implemented across the networks.
Let me ask a real quick follow-up, Phyllis. What about cost? Is MFA really expensive? Is it modestly expensive, or is it not very expensive at all?
So it really depends on how you choose to implement it. MFA is something you have, something you know, and something you are. So that includes your password, which of course everyone is used to authenticating with today. Additionally, MFA is provided free by some service providers such as Google. So for example, they can email you an additional password, or you could get a text message via your cell SMS to provide you an additional MFA authentication code. Or it can get pricey, where you will actually have a separate hardware token, and that's how you will get access to data or to an additional application. So it really runs the gamut. There are pluses and minuses as far as security goes for some of the different solutions. However, we do believe strongly that MFA, even the ones that perhaps some folks would consider less secure is better than just username and password. So we do believe that it's achievable for most organizations.
All right, thanks. Chris, I don't plan to call on everybody separately from this point forward, but I do want to look to you next at least. We're going to assume that you were the consultant to the app builder, so to speak. What do you have to say about the suggestion that multi-factor authentication really should have been used here?
Yeah, well, yeah, and to prevent myself from playing too many roles, I'm going to put myself in the position of the actual application architect here, and I'm going to act as my normally the position my clients are in. I'll say everything I'm saying now. I see people having challenges like this, but in the case of this hypothetical, the application that we just described, it's a health tracking app, and it's very useful for our customers. And what they do is they wear a watch, and they've got a desktop application they can use in their browser, and it's taking their watch is taking vital health information from them and sending the data up, and then allowing algorithms to work, and then advice comes back. So it says, hey, we're noticing your blood pressure's up, and we're also noticing that you're very active before bedtime. Why don't you take 90 minutes? Because it seems to be working for everyone else. They take 90 minutes before bedtime to relax, their blood pressure improves. So there's a lot of health benefit to people. The challenge that we had with multi-factor authentication, why it's not on the application, is because we had difficulty with our implementation of it. It slowed stuff down, and the method we were using was a soft cert on the watch device. And it was causing difficulty approving and affirming that the user was who they were. Our red team was also able to subvert the use of the soft certs on the browser. So we weren't really happy with that solution, and we removed it, but we replaced it with something else where the seniors could use a gesture on their watch to validate it's them. So they're ready to start their day. They have a gesture that they put on their watch, and then they move forward with their day. But we found that reduced usability quite a lot. A large percentage of our users stopped using the application, stopped getting the utility of it, stopped getting the benefit of it. So we realized that wasn't a solution. So then we turned to CIS and said, what else can we do? So what other alternatives do we have? That's my question now to Phyllis.
Yeah, sure. So there's something called risk-based authentication. And so you'll see that many applications do this already. So for example, if you were to log in to your bank account, many of us do online banking. Typically, it's with username and password. I use my same device every day. If for some reason I updated my device with a patch, or I decided I was on vacation and I was using, a library workstation, the app will most likely, the banking app will say to me, hey, this is an unrecognized device. I want to verify that this is really you. How would you like to get your additional access code? Via email, via text, or via voice, right? Whatever data you put in when you first set up your bank account, it'll prompt you for that, right? And then I can respond accordingly, and then I will get my additional code, access code, and I can type that in. Many applications do this either via perhaps time of day. They note when you are actually using the application, or area code or location, device, etc.
Okay, that's very helpful. So then what I do is I take that idea and I put it into my risk assessment method to see if the alternative you just described gives me a reasonable level of security. And CISRAM evaluates the reasonableness of security in a way that's very similar to the test in the Sedona conference. But while I have no multi-factor authentication, I removed it because seniors weren't using the gestures. I got hacked, and there were complaints, and that's when I heard from Jim.
Indeed, and I was remiss in my introduction. I do need to state that the views I expressed today are my own and not necessarily those of the Federal Trade Commission or any of the individual commissioners. This is a scenario where Chris would be likely to hear from the FTC. And one of the reasons for that is we're talking about health-related data that in the FTC's view is going to be, on the continuum of potentially requiring heightened protection because of the sensitivity of the data and the harm that can be caused to consumers if the data is breached in some way. It also stood out to me that the discussion has indicated that a lot of seniors are using this particular app, and one of the consequences of the breach that has been noted is that the seniors have been subjected to particular types of scams. The app developer's knowledge that its user base included a substantial percentage of seniors is going to raise questions in the FTC's mind about how the app developer accounted for that characteristic of its user base in assessing risks, including the risk of not having multi-factor authentication. And we've seen, based on the fact pattern that's been described, that this data is actually on the dark web. So we're going to have concerns about significant harm being caused. That said, I want to stress that the mere occurrence of the breach does not necessarily mean that the commission would conclude that the app developer failed to employ reasonable security. To determine whether the app developer did fail to act reasonably, the FTC would ask questions designed to learn why the app developer didn't use MFA. We would want to consider whether it is an industry standard or custom to use MFA. And in drilling down on that, again, we're going to consider the type of data that's at issue here, and are going to be looking for the app developer's risk analysis to have accounted for the sensitivity of the data. We would also want to know why the app developer and how the app developer decided that the use of soft cert would be a suitable alternative to manual multi-factor authentication, and would ask questions designed to assess whether the app developer's decision to rely on the soft cert was reasonable. Then, because Chris has mentioned that a pen test showed a vulnerability with the soft cert, we're going to want to know what, if anything, the app developer did to address the vulnerability with respect to the soft cert instead of just turning it off, including, for example, whether what the analysis was when the app developer considered things like enhanced monitoring of logins, perhaps consideration of doing things like monitoring the IP addresses from which logins were occurring, or limiting the number of logins per IP address. As Phyllis indicated, there are a number of ways of getting at what, as Phyllis described, are very well-known risks having to do with compromised credentials, and running into a problem with one control that was put in place doesn't alleviate the need to make sure that those risks are still being addressed in a reasonable way. And having a long-term plan for addressing the risks doesn't alleviate the need to address the risks in the short term. So we'll have a lot of questions to ask Chris and the app developer.
Jim, let me jump in and ask a question of you, because we're there in the presentation so far. And you helped develop this test that the Sedona conference came up with. In your view, does this test help either the FTC, or in this case the app developer, or both of them, communicate with one another about whether the work by the app developer was reasonable?
It does, to the extent that the test makes it clear that cost benefit analysis is the way to assess reasonableness. And it makes it clear, as from my perspective, I think it's always been clear that reasonableness is not the same thing as strict liability for having a breach, as I mentioned. And it's not, it doesn't presume that all potential further investments in security are warranted in order to act reasonably. Where I think I differed from some of the people that were part of this collaborative process is I start from a different premise that I believe that there are many external markers of reasonableness, such as industry standards, best practice recommendations, guidance that is published by civil law enforcement agencies or regulatory agencies like the FTC, state attorneys general offices, organizations like the Center for Internet Security. And there actually is substantial commonality in all of that guidance in terms of what types of risks should be addressed. What there's not, and what I don't think there can be, and I think the Sedona proposed test is consistent with this view, is that can't boil down to a checklist of telling everybody who is collecting data that you should implement this particular control in your environment. It's always going to be about the sensitivity of the data that's being collected, the nature of the particular business's operations and the complexity of its data operations, as well as the cost and availability of tools to reduce known risks. But I think that any discourse that the Sedona conference can advance on reasonableness is warranted. One other thing I want to mention briefly is that I also differ a little bit with some of my colleagues who were part of the drafting team for the Sedona paper. And by colleagues, I mean non-FTC colleagues, in that the reasonableness test when it comes to what is an unfair practice under the FTC Act, I don't think has been difficult to ascertain. The statute sets forth the particular criteria that I mentioned in my opening remarks, and that's going to be the criteria that the FTC evaluates, or that a court is going to evaluate in determining whether a business entity has committed an unfair practice by having unreasonable data security practices.
All right, Chris, I'm gonna turn briefly back to you. We've heard, or you've heard now from the FTC. They're interested in what's going on. They want to have a conversation with you. Perhaps this is a moment where you'd engage David.
You bet. And he's been very successful at defending people in my spots, so I'm not going to say another word.
All right, well, I think it's my turn to chime in, it sounds like. Yeah, so I come at this from the perspective of a defense attorney who is charged with defending the reasonableness of our clients' security measures. And thinking about this in terms of the test that the Sedona conference put out that balances the costs of the proposed security measure versus the benefits. So let's talk about that in the context of this particular hypothetical. And what I would say is it's really critical for me as a defense lawyer to help make sure that whether it's a regulator or plaintiffs' lawyers, that the benefits of this proposed measure are not being overstated, and also that the costs are not being understated. So let's think about the benefits. Here it's the proposed measure that's being thrown out there is MFA. And even if there are benefits to MFA in the sense of lowering the risk that this personal information could be stolen, it's important not to overstate those risks. In particular, you have to look at what measures the company already had in place, which forms kind of the baseline. And it's not as if companies don't have anything in place. They already have substantial measures in most cases. And in this case, Chris mentioned that the company already had a soft cert security measure that was in place, at least for a time. And so the question is, how much would MFA really have decreased the risk of that data getting stolen, when you keep in mind that the company already had other security measures in place? It's not as if the risk without MFA was like 100% or anything like that. You have to look at what is the risk without MFA, compare that to the risk with MFA. And then you also have to think about the fact that just because data is stolen, and I'm sure Jim is going to disagree with me on this, but not every case in which data is stolen automatically results in consumer harm. You also have to look at the risk. What is the likelihood that after data has been stolen, that the criminals are going to be able to successfully misuse that data and thereby cause harm to consumers? Now that kind of raises a thorny issue of what is the definition of harm, et cetera. But you have to think about that because, for instance, if we're talking about harm in terms of the hackers scamming these consumers into losing money, you have to keep in mind they're not always going to be successful in doing that. The risk is not 100%. That the criminals are going to be able to scam consumers into losing money. So you have to think about there has to be a rigorous analysis of what is the actual likelihood of harm if there's a breach. And then you also have to look at the threshold question of how much would MFA really have decreased the risk of the data being stolen. And until there's been a really rigorous analysis of those two questions, you can't really say what the benefits of MFA are for purposes of the test. And then when you get over to the cost side of the analysis, I heard Phyllis mention that there are costs associated with MFA, and those cannot be ignored under the test. There are all sorts of costs to be taken into account. A key one that Chris mentioned is lost utility. When they had tried certain forms of MFA and were considering other forms of MFA, they realized that having another factor of authentication was causing these consumers not to be able to use the app properly. And that was a lost benefit to the consumer. And that lost utility both to the consumer and to the public in terms of the scientific value of this data has to be taken into account. There are also costs to the company that have to be taken into account that are associated with MFA. Phyllis, you mentioned that MFA can be pricey depending on how it's implemented, right? And you have to think not just about the cost of the out-of-pocket cost to obtain the technology, although that's one of the costs, but you also have to think about all the other costs. You have to think about the labor costs involved in maintaining the technical aspects of MFA. You have to think about the customer service and customer support costs that are going to arise from dealing with problems that consumers have using the MFA. You have to think about lost revenue to the company if these consumers are getting fed up with using the MFA and just stop using the service. Keep in mind, these are frequently elderly consumers who may not be as technologically sophisticated as younger consumers. So all of those costs, in my mind, especially as defense counsel, have to be taken into account. And a key role that I would play is making sure that those costs are not being understated and that the benefits of MFA are not being overstated.
So David, let me ask a question, also going back to Chris.
Yep.
How would the Sedona Conference test for reasonableness facilitate your conversation with Chris, your client in this case? Mm-hmm. And then after that conversation, how would the test facilitate your engaging the FTC, who wants to know all about your client?
Yeah. Well, I think one of the things that's really helpful about the Sedona test is that it identifies a lot of the key facts that need to be developed in both working with the client to understand why they had the measures they had in place and didn't have other measures in place, and understanding how that can be assessed from a reasonableness perspective. So for instance, lost utility, that's something that needs to be investigated. What loss of subscriber base would occur, and what other difficulties would consumers have with these additional security measures? That's something that needs to be investigated, and that's something that in my conversations with Jim, and if necessary, if it went into litigation, the conversations that Jim and I would both be having with the court would involve those types of facts: lost utility, other costs, labor costs, out-of-pocket costs. I would be making sure, with the assistance of the test that the Sedona Conference developed, that I'm pointing out that these facts matter, that these facts are relevant to the test, and that they have to be taken into account.
So Jim, they come back to you and they have this presentation that they'd like to make to you. And let's suppose that they begin the conversation by making this proposition. Why don't we have our conversation based on the Sedona Conference test for reasonableness? Is that okay with you, Mr. FTC?
We can certainly have the conversation on that basis, and they're under the test. I think there is plenty of room to debate and perhaps come to different points of view as to what is a relatively simple test goes on which side of the equation. And one of the areas where I imagine we would be having a fairly robust discussion is on the sort of loss of utility arguments that David highlighted, and how relevant they are and how much they would weigh into the FTC's assessment of reasonableness. While David seems confident that there would have been a substantial loss of utility because consumers and some senior consumers in particular wouldn't have used the app if MFA were required. I'm probably going to have substantial questions about about the loss of utility by consumers who never used this app because they weren't going to entrust this type of data to an app that wasn't using MFA. So my frame of reference for loss of utility may be quite different than David's. And I'm also going to want to know whether choices were presented to consumers, and if so, why not? and how that factors into, the general statement that consumers wouldn't have used the app and the benefits that otherwise could have inured to consumers at large wouldn't have occurred if MFA were part of the app. And then also, it sounds like we may be whatever information the company may be relying on to say that there would have been a loss of utility may have resulted from information asymmetries. Did the company do anything to warn consumers about the trade-off from the company's decision not to use MFA? And did the company revisit that decision when it determined that there was a vulnerability in the soft cert that the company was relying on as a alternative way of addressing some of the risk associated with compromised credentials? So I think, yes, the framework that's laid out in the test could help facilitate a useful discussion. And I think that the framework probably is going to allow for disparate views to be exchanged in terms of what fits where and how much weight to give to what.
Okay, let me turn to Phyllis for a second, and because of something that Jim has just raised, where do we go for data on consumer use in the face of the presence or absence of a given control, such as multi-factor authentication? Is there helpful research out there? Is there helpful commentary out there? And is this something that CIS can help people get a hold of?
So there's always this tension between what we would call usability, which I think we're referring to as utility here, and security, right? There's always that tension. Less usable, more secure. Why do I have to memorize a longer password? Why do I have to get an SMS message on my cell phone? I only want to just do the one click, buy my Amazon thing. There's always that tension. Microsoft did a big
for that, by the way. While we're
So Microsoft did do a big study, arguably, an organization that has hundreds of millions, if not over a billion points of, data points around, authentication, authorization, multi-factor authentication. And they did say that, you should be using MFA. Now, as far as the usability of it, they made claims around, of course, their product and the usability of enabling that in Microsoft. Mm-hmm. However, I will say the data overwhelmingly says that MFA is doable and something that you should implement. Having said that, I will say that when we talked about MFA in creating controls version 8, we had representatives from smaller organizations, as well as NGOs, non-government organizations, who are always thinking, well, how am I going to implement this? And an example would be, outside of this case, is if you're, for example, doing disaster relief in a third world country, are you obligated to provide MFA if the infrastructure is not there, if all these other things are not there? And that's not necessarily usability or utility per se. Well, I guess it is, but it's more, if you physically cannot do it because it's not reliable, do you have to do it? And so what I would say is, there are some studies talking about the efficacy of MFA and some about the usability. Additionally, I like this idea around reasonableness and using also what we have, the CIS RAM, where you can document it and really show why you made the choices that you made, and hopefully make them defensible.
I really think it has to be assessed in terms of the feasibility and the cost and the benefit. It has to be, in my mind, on a case-by-case basis, based on the specific facts at the particular company in question. I think even if there are studies out there that, as a general, talking about the general benefits of MFA, you have to look at the specific company in question and find out what feasibility and cost issues would they have experienced based on their particular business, and also based on how their specific network was set up, and how their business operated. What would the extent of the benefits of MFA actually be when you take into consideration the specific security measures that they already had in place? So I would, as a defense lawyer, kind of try to make sure that the conversation is focused on the specific facts of the case as much as possible.
David, on that point, let's say that you've heard a mouthful, so to speak, from Jim Trilling. How about everybody uses MFA, and why on earth don't you use it? And so now you turn back to Chris Cronin, and you say to Chris, we got to come up with an answer here. We've got this Sedona Conference test for reasonableness. Does this help us in any way to counter the arguments of the FTC that multi-factor authentication was a minimum in this context? Chris, what do you think?
In the couple of minutes we have left, what I'll do is quickly say, to address David's point about the architecture. This is based on things that I've seen in real life. The application is designed so that when someone gets access to an account, they can only see the essential records of that one account. And our risk analysis looked at the possibility of one account being hijacked. And we thought that we measured that one account being hijacked versus the entire, significant part of the population not using the application with an intrusive MFA. We did not foresee the risk of a very large attack like what we have in the scenario. So still using the test, using CIS RAM, we'd done the risk analysis. We just didn't actually see what came. And then, David, we'd probably have a conversation about how to present whether I was doing what I believe was foreseeably appropriate.
Why don't we take this time left? We've got 2 minutes left. We got time for a fast wrap up. So, Jim, let's start with you. Why don't everybody take 30 seconds and just make whatever closing comments you'd like to make? Jim, go ahead and start.
Well, I think that the discussion today has showed that there is a lot of agreement as to what the considerations are for reasonableness, including what types of standards and customs may exist, and the paramount of importance of taking into account the nature and sensitivity of the data that you're talking about securing in the particular environment.
Okay, Phyllis, how about you?
Yeah, it's been a great discussion. I will say when we do create controls documents for the most part here at CIS, we believe that the bulk of organizations can implement all those safeguards, and that we've done the research and the data to show the efficacy of that. However, the reason why we provide something like a CIS RAM is so organizations can make individual decisions, because at times, there are exceptions to the rule.
David?
I would just say that the costs and benefits of a proposed measure have to be analyzed rigorously from the perspective of the specific company at issue, and every company is going to be differently situated, and I think that is something that has to be taken into account. And I would just always caution that that no security measure is costless. You have to take into account all the costs that come associated with that, both to the company and to the consumer and to the public. And also we have to be careful not to be overstating the benefits of whatever security measure is being proposed.
And Chris, we'll let you wrap things up for us.
I'm just pleased that we've reached a milestone in the industry where the regulators, litigators, and information security people have come to agreement on what reasonableness means. So I'm happy we're at this point.
Well, thanks to all of you, and thanks to the RSA for letting us have this opportunity to talk with you. It's been a lot of fun for all of us.